Well, good evening, everyone. I'm Barry Bussey, and welcome to our live stream. Tonight, we've had a little bit of technical issues. One of those, as you can see behind me, our green screen virtual background hasn't worked, but we'll try this again, and hopefully we'll be able to have a good discussion tonight. So tonight, I'm just going to be kind of having a little bit of a, what would I say, kind of a general discussion. It's going to be a little different than the usual time when I'd have a special guest to talk about the issues. But I encourage you to put on your comments and your questions because I'll be happy to have a opportunity to be able to answer as best I can. And if I can't get the answer for you, I will certainly do my best to get it for another time, or even we can communicate in a private way. But tonight I want to talk about the Charter. The Charter has been now 40 years since it received royal assent. And for those of you who can remember, as I can, I was but a teenager at the time, but I do remember I was very much politically attuned for a young person, and I was remember very clearly watching on the news and also hearing about the fact that Queen Elizabeth came in April of 1982 to Ottawa, where the Constitution was signed, and we had the Canadian Charter of Rights. Now, I want to talk about a little bit about the reasons why this charter was seen to be necessary. It certainly was seen to be necessary, according to Pierre Trudeau. This was kind of like his life project. He wanted to have Canada with a charter, a Bill of Rights, as it were. But it's something that goes back even further. If you remember in your Canadian history, for those of us who have had Canadian history as part of our education, you'll remember that John Diefenbaker also had a desire for freedoms to be entrenched, except, of course, he had struggles with trying to get everybody on board to have an entrenched charter, Bill of Rights. He referred to it as the Canadian Bill of Rights. But even further back in the 1920s, we had prime ministers trying to figure out how to solve the gaps that are in our Constitution. Now, unlike the American Constitution, which has just one document, Canada has multiple documents as part of our Constitution. And so one of those documents is now called the Constitution Act 1867. I grew up going through school and so forth, calling it the British North America Act. And that was of 1867, where as a result of the various conferences held by John A. Macdonald and all the various representatives of the British colonies at the time, British North America, they came together, as you know, down in various places around the country, whether it was in Quebec or down in Charlottetown and so forth, are trying to figure out how they were going to craft this country. Now, one of the reasons why it was so important to have a country was because the North won the Civil War. Many people don't realize that, but that was a big issue, because the fear was that the American colonies, remember, America attacked Canada even during its revolution in the 1700s, in 1776 and onwards and so forth. They had the attack on Quebec City, and the attack on in Montreal. And then, of course, in 1812, we had the other war where, again, the Americans attacked Canada, or what was to become Canada. And so there was always within the Canadian psyche the idea that the American experience would be such that it would try to take over what is left of British North America. And indeed, various U.S. senators, politicians, and so forth had this idea of this manifest destiny, where they would literally take over the North American continent. So when the North won the Civil War, there was a real sense that the victorious army would swing north and do the unfinished business that was the history of North America, at least European North America, as to the fact of taking over Canada. And so it became very important for Canada to have to come together as a defense mechanism. And that was one of the driving forces for John A. Macdonald to extend the railway across put the ribbon of iron across the prairies to British Columbia to connect British Columbia with the rest of British North America, so that if there was ever an attack against Canada by the Americans, we would be able to send the troops out on the railway to be able to defend the border. So that was that was a big concern. Now, in the midst of all of the discussion, there was no thought given to an amending formula. How was this new country going to be able to amend its own constitution as it grew, as it matured as a country? How were you going to do that? And that was left unsaid. There were other things. There was no mentions of Bill of Rights or anything of that nature. But yet within the cultural concept or the cultural milieu, there was this sense that when Canada became a country, it was going to have all of the British law that would be coming with this new country. So in other words, the principles of the legal system of Britain would be applied within the Canadian context. So it wasn't as if we didn't have rights. We had the rights. There was always this sense within the British common law, within the British constitutional mindset, that there were rights, and those rights came with us through even in the preamble of the Constitution Act of 1867. But there was the problem, though. How do you amend the Constitution when things change? And things do change. The economies change. The technology changes. And how do you deal with that? And so it became very, very difficult as time went on for the politicians. And in the 1920s, there was a concerted effort made to try to bring the provinces together to try to come to an agreement. But there was no agreement. And this continued on decade after decade after decade. And then in the 1950s, under John Diefenbaker, again, another attempt was made at putting in the idea of having Canadians having an entrenched Bill of Rights. Well, even the experience of World War II and all the rest still didn't give us an entrenched constitutional Bill of Rights. John Diefenbaker, what he decided to do was to pass a piece of legislation which gave us the Canadian Bill of Rights, but that is only a piece of legislation. In other words, any subsequent government can simply change that Bill of Rights. And so it didn't have that constitutional rigor so that it would be applied across the country in all of the provinces and all of the territories with respect to municipalities and so forth. But obviously under the federally controlled areas, it would apply. So this became a big issue as well during the what we now know as the Quiet Revolution in Quebec, where Quebec was wanting to break off its chains, as it were, or as they would refer to it, with respect to its own culture, its religion, and so forth. And they were wanting to have more this concept of a revolutionary spirit that kind of pervaded through Quebec. And one of the young intellectuals of the age was a guy by the name of Pierre Trudeau. You may have heard of him. And he decided that in the early period there, in the 60s, if not in the late 50s, he wrote an article calling upon the entrenchment of a Bill of Rights in the Canadian Constitution. And this became something that he was really motivated on. He wanted to make this change. And eventually, of course, he became the Minister of Justice. And again, he began laying the groundwork. And then when he became Prime Minister, he entered into this project in earnest. There were multiple meetings with the premiers and so forth. And then finally, in 1971, in a meeting in Victoria, British Columbia, the provinces and the Prime Minister agreed to a charter. It was known as the Victoria Charter, wherein there would be an entrenched Bill of Rights. There would be an amending formula. And the amending formula included, though, a veto power for both the province of Quebec and Ontario. Okay, so you can imagine now, it's kind of like having what we have now, the Security Council at the UN. If any member of that 5-member Security Council, if they decide with the veto power that they're not going to agree with it, then it stops. And so in this case, the Victoria Charter of 1971 said, well, Quebec and Ontario will have veto power. And even though you have the majority of the rest of the provinces wanting to do an amendment, each of these provinces would be able to veto it. Okay. It seemed like everything was okay when everyone left. However, Robert Bourassa, when he came back to Quebec, there was a sense of, well, no, we need something else. We need more than this. What we need now is we need to have a mechanism whereby we would have the right as a province to be able to do social programming, but that the federal government would pay for it. And Trudeau disagreed with it and said, no, that's no deal whatsoever. And as a result, Robert Bourassa, he ended up saying, no, he's not going to sign the Victoria Charter. Now, this, as Trudeau talks about in his book, in his memoirs, he was saying that this was a very unwise thing for Bourassa to do. And ultimately, as far as from Trudeau's perspective, talking about Pierre Trudeau here, that the failure of the 1971 Accord ends up causing more division in the country and ultimately leads to the Parti Québécois taking over power in 1976 under René Lévesque. So, again, it looked like at this point when Parti Québécois took over in Quebec, it seemed like that Trudeau's plan for a charter, for an amending formula and so forth was lost. Like it was kind of like the end of the road, as it were. And yet he decided that he was going to try again. And so what he did was during the election of 1979, he made the Constitution first and foremost in wanting to bring the country together. However, Canadians were more interested at that time in the whole idea of, remember, inflation was running high, jobs were a problem. They wanted to be able to put food on the table, and Pierre Trudeau was concerned about the Constitution. It just didn't jive. He went against his own counselors and those around him who said, look, let's lay the Constitution aside in this election campaign of 1979, and then we'll come back to it later. And Trudeau said, no, his gut was he needed to get this Constitution thing settled. Well, as a result, Joe Clark then became Prime Minister. And Joe Clark had a more of an accommodating approach. Canada is the community of communities and so forth. And so it seemed like Trudeau's days were over. In fact, he decided that he was going to resign and his leadership in the party. And ultimately, that's what he did in November. And soon as he resigned, at that point, René Lévesque, the Parti Québécois, decided that they were going to hold a referendum now in the spring of 1980. They felt that with Trudeau out of the way, they would be able to have a successful run at the referendum to take Quebec out of Canada. Now, what was fascinating, of course, is that during this time, Trudeau really wasn't much of a opposition leader. He lost a lot of energy as a result of his project falling apart. But then, of course, you know what happened. For those of us who've studied history, we recognize that Joe Clark was only in for 9 months. As I remember John Crosby making a quip, something about they were so young as a government, they didn't even have time to have a baby, you know. And it was because of John Crosby's budget, or at least that was the reason, that they lost the non-confidence vote, in particular because of the tax that was going to be put on gasoline, which, interesting enough, just a side note, that when the Liberals then got in power, in February of 1980, when Trudeau got in government, he raised the tax even higher than what John Crosby's budget was. And that was the reason why they lost the election. Anyhow, just fascinating things about history. Anyhow, so then what happens is that Trudeau now becomes prime minister yet again in February 1980. And if you saw any of the videos or anything like that, he says, well, welcome to the 1980s. And everyone went crazy and all excited because Pierre Trudeau won again. Okay, so now, with the referendum coming up in the spring, Parti Québécois and René Lévesque had planned, were disappointed, of course, that Trudeau had won the federal election because of his stance against the separatists in Quebec. And now Trudeau puts his heart and soul into the referendum. And by the way, I should say that part of the reason why he won the 1980 election is that he learned from his mistakes of 1979, and he didn't want to deal with the Constitution so much during the election. He wanted to talk about the bread and butter on the table kind of thing. And as a result of that, he got elected. But then as soon as he was elected, it was the Constitution. So anyhow, what ends up happening is that the referendum is lost, and Trudeau now feels empowered even more to get a Charter of Rights. And so now he pushes for the Charter of Rights, and he's trying to get the various provinces on side. But what ends up happening is he creates so much division between the provinces and the federal government that a group of premiers, they were known as the Gang of Eight, of which the Honorable Brian Peckford, whom we hear a lot about today in his case right now, to go against the vaccine mandates as far as flying and so forth for travel. But he was among the Gang of Eight, and as well as René Lévesque. And so they went to court because Trudeau said that, look, if you guys don't agree with respect to the Constitution as I've outlined it with the Charter and all the rest of it, I'm going to take the case to London myself as on behalf of the government of Canada. We're going to go it alone. We're going to get the Charter. We're going to get the amending formula that we choose, and you guys are going to have to live with it. So they went to court. They went to the Supreme Court. The Supreme Court said, look, yes, the federal government has the authority to do legally to go ahead and do it alone. However, there is a constitutional convention that says you have to have a substantial number of provinces to agree with your project. And so as a result, they ended up having this kind of a nebulous decision. And Trudeau was told by his advisors, and as well as he recognized it, that he must get more approval for his project or else the whole thing is going to fall. And so as a result, he tried yet again to have a coming together of the premiers and trying to hammer it out. But now here's the problem. Here was the crux of the whole matter. The problem was that the premiers were concerned about the role of the judges when a new charter came about, because they were afraid that we would be ruled by the judges rather than ruled by the legislatures, both the province, the provincial, and the federal legislature. Now you're going to leave it up to the unelected judges. And this was a big debate as to how you deal with this situation. How do you create a charter that's going to respect parliamentary democracy, but also respect rights at the same time? And this was becoming the real crux of the whole debate. So what happened then is that they had a meeting in Ottawa trying to bring it all together. And what Trudeau then decided to do, and he admits it in his memoirs, which is absolutely fascinating. By the way, if you ever get a copy of Trudeau's memoirs, I encourage you to read it. It is fascinating reading. What he did was he decided that he wanted to break up the Gang of Eight. And so he basically said in a side meeting with René Lévesque, he says, look, René, why don't you, wouldn't you agree? I mean, you're a Democrat. Wouldn't you agree to a referendum? Like, in other words, we will have a referendum on this, on the issue of the charter. And surely you would agree with that. Well, all of the provinces said there was going to be no agreement with respect to going to the people with respect to the referendum, because they felt that the federal government, having the bigger means, with being able to speak to the people, having the bully pulpit, as it were, that they would probably lose in a referendum. And René Lévesque agreed. Now, what that did was that it created a fissure between René Lévesque and the rest of the provinces. And it was seen by the other provinces is that Lévesque was basically throwing them under the bus. When that happened, it seemed like Trudeau had created the wedge between the separatists of Quebec and the rest of Canada. And then he was threatening he was going to go alone. And so that's the meeting ended that day with Lévesque going his way, with the rest of the provinces in a disarray, and the Prime Minister saying he's going to go to London alone and he's going to get this charter through. Okay, what ends up happening? René Lévesque called it the Night of the Long Knives, and because this is the what has become the idea that Quebec was left off, and that Quebec was hard done by the rest of the provinces. And so what happened was that a group of meeting, Jean Chrétien was the go-between between Trudeau and the rest of the provinces, the premiers and so on. And they began chatting and began talking. Look, there's got to be a way to resolve this. And ultimately, what they decided to do is they would put within the charter what we call now the notwithstanding clause. In other words, the provinces were saying, look, we will allow to a certain degree that the judges will have the say with respect to the rights, but ultimately it's the legislatures that will decide when it comes to the various its plans and so forth, whether or not it was going to be supreme, as it were. Now, so then what happened was they came to this formula, and they came with an amending formula, 7 provinces with 51%, which means that you can then have an agreement with either Quebec or Ontario, with other provinces that meet that reach 51% plus one of the population to be able to amend the Constitution. So no longer will you have a Quebec veto or an Ontario veto, but you will have to have, just because of the nature of the way the population is, you will have to have at least Ontario or Quebec being among that group to be able to pass an amendment to the Constitution. Okay, so that was one. The other thing was the notwithstanding clause, and which basically says that you can have, i.e., the legislatures can have veto over the rights, so can limit the rights for its legislation, but that is only going to be for a 5-year term, but that 5-year term can be renewed. And of course, that was put in there so that it wouldn't be forever, and that we would have public discussion every 5 years on the issues that the notwithstanding clause was used for. So as Trudeau said, he said in his book, it was not perfect. He preferred not to have the notwithstanding clause, but he preferred to have a charter with a notwithstanding clause than no charter at all. And he says, for Trudeau, it largely enshrined the values that he'd been advocating since he wrote his first article. And remember, I mentioned to you about the article. It was actually in 1950. And so it was indeed his magnus opus. He got the charter. Okay, so now let's have a look at the charter. So the Charter of Rights is something that is, it is the supreme law of the land as part of our Constitution. Remember, for those of you who are just joining us, the Canadian Constitution is not just one simple document. It is a document that is multiple documents. I don't know exactly the amount of documents, but it's up getting close to like 20 documents form the basis of the Canadian Constitution. So it can be quite complicated. Okay, so when we look at the Canadian Charter and we look at what has happened since, we've got two various opposing views, which originate, remember, back in the time of all of the debates, who's going to have supremacy, the legislatures or the judges, and that becomes a key matter. And it is still a key matter even to this day when we see a number of decisions being made. Is it the legislature or is it going to be the judges who decide public policy? And that becomes a very, very important matter to deal with. I just want to point out some of the commentary that we've received over the last couple of days with respect to the Canadian Charter. Looking back, one of the groups, one of the individuals actually, who has been very vocal against the Charter is Ted Morton. Ted Morton, out of Alberta, has written a very interesting book, Law, Politics, and the Judicial Process in Canada. This is a great book. He also wrote a book entitled The Court Party, and I have it here somewhere, but I can't seem to find it right now. So his idea and his argument is this, that we lose as a country when we have a government that's going to be basically commandeered by judges that make all the rules or with respect to public policy. But now you have to kind of step back. Now I step back a little bit, because it's not just simply that they make all the rules. It's just that they are the ones who the arbiters when there are conflicts between, say, the federal government and the provincial governments and so forth. One of the things that he points out is that it's the biggest losers since the Charter has come into play are the provincial governments. And he says that what was going on is that this was a risk that was evident from the very beginning, and of course is one of the reasons why the provincial premiers fought so hard to have that notwithstanding clause, right? So that they would be able, as legislatures, be able to do it. Ted Morton points out that what what we have in Canada is a situation, and I have some sympathy with his argument. What he says is that, look, if you look at the judiciary, you look at the universities, you look at the bureaucracy in Canada, you have a situation where there's almost kind of like a groupthink. That's my words here, not his words, but there's this kind of alignment with respect to how Canada ought to be run. And one of the arguments that what he calls the court party have is this idea of a stigmatization with the use of the notwithstanding clause. So in other words, we make it so horrible to use the notwithstanding clause that politicians are afraid to use it. And I'll just read this from his article, which was published just a few days ago. He said, why the infamous Section 33? The same groups that have benefited from the court's charter activism and their allies in the universities and national media have worked tirelessly and successfully to stigmatize the use of the notwithstanding clause. Other than Quebec, provincial governments have been reluctant to use the notwithstanding power for fear of media attacks and political backlash. The net result is that there are now broad areas of provincial jurisdiction where public policy is essentially set by the Supreme Court and its interest group supporters, a coalition that I dubbed the Court Party. And so what he says is that from a provincial point of view, he says that the Charter of Rights and Freedoms was one of the worst bargains ever struck in the history of Canadian federalism. And he goes on. I might as well just go on with his argument, and then we can come back and have a look at it. He says that federalism is itself a form of protecting minority rights. So you can understand this mindset here, his point that because we have a country where we have different provinces, that in essence creates minorities. In other words, Quebec is one minority, compared to the rest of the Canada, but so is Ontario, so is Alberta, so is Newfoundland, and so forth. And so he says, look, within federalism itself, there is a sense of minority. And he said it's a... in practice, it is little more. He said he goes on and he says that each province is a minority, and he says that, but this version of Canadian federalism, the idea of federalism, is being sacrificed on the altar of a new version of minority rights. And so he says, look at the winner circles. Who is it that's winning under this arrangement with the charter? And here's what he says. He says, if you look at the winner's circle, any policy touching on bilingual education, Aboriginal issues, abortion, LGBT or feminist issues, prisoner voting rights, and so on, if a provincial government does not accede to the interest group's demands, that government can expect to be hauled to court and are usually going to lose. So this is Ted Morton, and he says, look, all of this is predictable. At the end of the day, he says the charter means what the judges say it means. And when it comes to going to court, the government, the federal government now has the court challenges program, which funds litigation costs of the interest groups. And of course, these groups, as Morton points out, are often liberal supporters because they are the ones that are going to get the money to make the challenges, the charter challenges in Canada. And now this is something that it's been controversial from the time Pierre Trudeau implemented this back in the day as well. And when Harper became prime minister, he ended the program. But then later, when the Liberals came back in, they implemented the court challenges program. Okay, so as we move on here, and by the way, if you have any questions, please just put them up in the comment section. I'll do my best to try to reach those as we get through here. So he says, look, here's the thing. The charter revolution has been energized by deeper socio-economic changes that have transformed the politics, not just of Canada, but the other speaking democracies as well. And so we got the middle class is shrinking. We get a white collar upper middle class, but then you got the blue collar lower middle class. So the white collar guys are all university educated. They're affluent. They're more progressive in their views. Then you've got the blue collar, and the individuals are more rural. They're not in the cities. And Ted Morton points out, look, okay, so these are the people that we're going to have problems with the various progressivism that's going on with respect to the courts. Now, and of course, you know, in the broad strokes, he says, like, you know, you just have a look at the truckers convoy this past February. Those are the blue collar, the more traditional moral, with the moral and political values and so forth. And then you've got the others who are saying, well, you know, this is, you know, white supremacy and all the rest of it that they go on with. Okay. So, what Ted Morton points out, he says, look, changes of the magnitude that have happened since the Charter require powerful support from influential people and groups. They are the well-educated, the affluent, connected elites to design and encourage and then support the transformation of Canadian politics that has taken since 1982. He points out there are some rays of hope with Doug Ford using the notwithstanding clause, as well as Premier Moe in Saskatchewan. Okay, so that's Ted Morton's view. Another view that I want to just point out is one that Professor Ryan Alford put out, and he said, look, we're coming down to a battleground here now when it comes to the Charter. And the battleground, according to Professor Alford, who's up at the Boralaskan Law School at Lakehead University, he points out, he says, look, those who hold fast, here's the two groups. Number one are those who hold fast to the idea that a constitution serves to limit the powers of government. Okay. Constitution limits the power of government. Okay. That's group number one. Group number two, he says, who see the Constitution, see the Charter as a means of empowering the government to achieve their vision of a just society. So on the one hand, you got the idea, and this is the liberal, when I say liberal, I mean small L liberal, the political philosophy. This is one of the problems we have in Canada. We've got a liberal party that is really not a liberal party in the political philosophical sense. But it is the idea that you limit the power of government, liberal being free. You allow the individual to be free. Or do you have the idea that you are to use the Charter as a means of changing society so that it can be more just? And so these are the debates that are going on and that the courts have to resolve. And so what Professor Alford points out is that that the judges, he says, look, it's not really all the judges' fault. It's that Canada's judges have shown time and time again that they remain true to their oath to impartially administer justice as the Constitution requires and not as they would have it. But he says we got this tension that's going on that is rupturing Canadian society, namely that there's no consensus within Canada about what it means to be a democratic society, i.e. small L liberal society, where we limit the power of government, we increase the power of the individual, or are we going to be allowing, in other words, the individual and the new minorities, as Ted Morton would point out, to have this concept of social justice. So we're into this debate where we're trying to make sense of how we are to live in a society when we've got such division. Now, what's interesting, Professor Alford points out, is that at times when the judges are making decisions, there's a big debate. This same debate that's going on in society is going on within the marble halls of the Supreme Court of Canada in Ottawa. And that is, and he uses the example of the case that involved a Quebec comedian who made a joke about a young fellow who had a disability. And the question is, okay, what is the extent of freedom of speech in this country? And 5 judges said, well, look, there is the idea that you should have the principle of freedom of expression. And yes, it's distasteful, but it wasn't vilification. Yes, it was not good, but it is part of the rule for freedom of speech in the country. So, but 4 dissenting judges in the case said, well, look, we shouldn't have this because you cannot just simply have a situation where you have marginalized groups who are being made fun of. And they went on to say that there's an onus now upon the individual who's exercising the right that they do so in a way that doesn't violate the idea of the equal exercise of the right. Now, let me just kind of open this up a little bit. All of the rights in the Charter are subject to Section 1, which says that you are given all these rights subject to reasonable limits that can be demonstrably justified in a free and democratic society. So in Section 2A, you got freedom of conscience, freedom of religion, you got freedom of expression, association, and so on. So you have all those rights, but those rights are subject to reasonable limits. But now here's what was happening in this Quebec case with the comedian. What the 4 dissenting judges were saying, okay, you can have the right, but the limit in the Charter is for the government to demonstrably justify that. Now the 4 judges were saying in this Quebec case, no, it's up to the individual to say why the right should not be limited. That is a total reverse of the way the Charter is supposed to be. And so a quote from Professor Elford, who says, ironically, a judicial vision of the Constitution, animated by the paramount values of equity and social justice, gives the state back the ultimate power to decide the limits of every individual's rights and freedoms. It need only frame these limitations as serving the ultimate good of democracy. So it's absolutely opposite of the even way the Charter itself has been organized and states. And so that becomes a real problem for us going forward in this country if we're going to have. Now, luckily, it was a 5-4 decision for the freedom of expression, but still, look at how close it was, and those 4 dissenting judges. Okay, so we got this ongoing debate that's going on right now. I can talk about all kinds of various cases where we have situations where the judges have been giving, in my view, a lot of power to the government and have been justifying the use of power and limiting the rights. I can give you, I've talked ad nauseum about the Trinity Western Law School case in administrative decisions. And this is one of the things that I think is a takeaway from what we've been experiencing with the Canadian Charter right now. And that is that we have a situation where the bureaucrats in government, those who are making the day-to-day decisions, who are not elected, they're hardly accountable to anybody. They are making decisions in the halls of government, and the courts have been saying, and this is fascinating to watch. The courts have been saying, as long as the government actor, is looking at the Charter when you make the decision. In other words, if you're mindful of the Charter and the obligations, and you make a decision, we're okay with that. You don't have to do too much as long as you're involved in the charter values, paying attention to charter values. And what's interesting, of course, is that charter values are not even in the Constitution. It's something that the courts have made up. So here we have the debate. We've got the debate of who's going to run in this country. Is it going to be the politicians? Is it going to be the judges? And then we have also the fuzzy middle of the bureaucrats. The bureaucrats are making decisions that affect you and I. And how those decisions are being made are something that the courts have to wrestle with. And it is implementing the government policies. But at the end of the day, we want to make sure that the courts are being very attuned to the charter. And one of the struggles that I've been having in recent days, thinking about the charter as we've come up to the 40th anniversary, which was just the other day on Sunday, is the whole idea of, for example, Justice Wagner, who's the Chief Justice, said that, look, we don't pay attention to what the words meant 150 years ago, basically in the 1860s, when the words were written on the Constitution. And I assume now the way the words were written in 1982. But we look at interpreting it on the basis of the here and now. And so that becomes a problem because then how do we wrestle with that? And it's become a real big issue for all of us, trying to make sense of how we make how we're able to deal with the idea of the law evolving. And I'll give just one example, and it's an example that Justice Wagner himself used, and that is the case of the 2015 Carter case, which was the medical assistance in dying, which is the euphemism for euthanasia, and they basically in the 1990s, the Supreme Court of Canada ruled that there was no right to medically assistance in dying. You can't make that right. The Charter Section 7, Life, Liberty, and Security of the Person, does not give you that right. And in 2015, they said, oh, yes, it did. And then a lot of people were concerned, well, this could lead to a further evolution, as it were, of more death, more assistance in dying to mentally handicapped or mentally people who are struggling mentally and so forth. Oh, no, this is not going to happen. And already we're seeing the governments moving more and more as the slippery slope. Yes, there is a slippery slope. Anytime that we see people say, oh, well, that's just a slippery slope, the fact is there is a slippery slope. And so we see that these moral values that the courts talk about are indeed moving. Now, what is fascinating is that even in that case, one of the real struggles, of course, is now medical practitioners who do not want to be involved in medical assistance in dying are now being told, like, for example, by the Ontario Court of Appeal, which says that the Carter decision, i.e. the Supreme Court of Canada decision, means that any physician who is unable to conscientiously follow the moral expectations of medical assistance in dying will, quote, have to seek out other ways in which to use their skills, training, and commitment to patient care. In other words, if you cannot follow the new medical ethic as determined by the court, find another profession. That's the language now we're at in this country when we're seeing individuals who have moral scruples with respect to getting engaged in these activities that violate their conscience. Basically, the court is saying, listen, you're going to have to sacrifice your personal conscience. And where have we seen that kind of attitude before or since? We see it now also in other areas. Anyhow, so those are some of the things that I wanted to just kind of point out that we're dealing with. The debates that occurred in the past are still going on right now. I do not envy judges. Judges have got a lot on their plate. This is something that is not easy to be able to decide these things. but it is something that we've got to be thinking about. When we think of government, we think of the executive, which is the prime minister, and we think of all of the government departments, part of the executive, and then we think of the legislature, the members of parliament that we elect, as well as the senators. And by the way, I can't say this enough, but I am so thankful for the Senate. The Senate stopped us from having the Emergencies Act continuing on longer than, and it shouldn't even been invoked to begin with, but thank God for the senators. So we got the House of Commons, we got the Senate, and so we got the judiciary. Now, all of these three areas of government are extremely important for us to be able to maintain a free and democratic society. We also have, people refer to it as the fourth estate, the media. And unfortunately, as time has gone on, the media have become, and I will make this criticism, that I have seen situations where the media have not been as robust in holding government accountable as they should be when it comes to freedom in this country. And I can give you a chapter and verse, but I won't do it right now. But here's the thing. We need everybody to understand the importance of having a society that is free and that is democratic, and one in which we can allow freedom to flourish. The struggle today, which these various critics have pointed out, we've got to struggle. We've got to struggle between the idea of allowing the individual to have the maximum amount of freedom so that we can still have civil peace. But then we've got also the idea that we have government to give things to us. So we can have social programs, we can have so-called social justice. No longer are we talking about equality as in equality of opportunity. Now we're talking about equality of outcomes. And that's a very different thing. And so therefore, the government now is expected to give us more. And that is creating tremendous amounts of tension. But in order for us to be able to live in a free society, we need to allow communication. We need freedom of speech. And that's one of the things that we do here at First Freedoms, is dealing with the freedom of speech. It is absolutely important. Just as Rand referred to it as important as it is to breathing. And I agree wholeheartedly. If you have any questions, those of you who are watching, I want to thank you so very much. And I'm sorry for, again, the delay as we started. But anyhow, we're here now. And if you've got any questions, I'm happy to answer any questions you might have. If there's anything that you would like to know with respect to the Charter, I will do my best to answer it. And if you could just make a comment right there, I'll give you a few minutes so that you have an opportunity to be able to do that. By the way, it's really fascinating as we deal with the Charter, deal with the 40 years that's been gone on. It's gone by very, very fast. But notice how much has changed in 40 years. A lot of things have changed. And it's important for Canadians to understand that we all have an important role whenever our society is evolving, as it has, and it has at a very, very fast pace. It's important for us to be engaged in communication, and freedom of speech is extremely important. And it's one of the reasons why I'm very concerned with the government's plan right now with respect to C-11, which is the censorship bill that's going to go on with respect to the internet itself. And anytime government tries to limit speech, we need to be standing up on it, and we need to be letting our voices be heard. That's extremely important. And so we want to be able to do that. Okay, I see that there are no comments, and I want to thank you so much for this great opportunity. And I thank you for supporting us. If you would just press that like button, And also, if you go over to firstfreedoms.ca, you'll be able to sign up for our newsletter. We send out a weekly newsletter of the events, all that we're involved with. And I want to thank you so very much for your time tonight. And until next time, I'm Barry Bussey. Good night.